Hello and welcome to the Attorney Connections Court Preparation video. The intent of this video is to get you as best prepared as possible. The key to being successful in court is being prepared and controlling what you can control to the best of your advantage. Please read the disclaimer below, and then the video will continue in about 10 seconds. So the first thing in being prepared is to make an outline at least a few days before your court appearance, if not maybe a week before. Sit down at the low stress environment of your home and where you can gather your thoughts and prepare an outline. And what you'll want to put on there is all the important information you want the judge to know that you believe is relevant to your case. It's best to make one with two columns. One column of what you want to say and what you were requesting and why, and a second column of what objections or other issues you think the other party will bring up that you anticipate and how you would respond to those. And focus on what is relevant. That is the key. That's what the judge wants to hear. The next step is you'll want to organize your documents and evidence. It's best to use a notebook. That way you have everything well organized and you can take that to court with you, and you know where to find your outline and any relevant evidence that you may want to present to the court, all well organized in that notebook. Bring a copy of all the papers that you filed with the court and whatever the other party served on you. Have those in your notebook as well. And if you have supporting evidence, bring it to court. What you'll want to do is bring 3 copies to court with you, one for you, one for the judge, and one for the other party. And again, have those well organized in your notebook so that you know where to find them when you need them. And in terms of deciding what to bring, just remember it's better to have something and not need it than need it and not have it. So if you're not quite sure, then just bring it. And also bring a notepad and pen to court so that you can jot down any notes or any responses you might want to say to what the other party's bringing up. You can jot those down, and then when it's your turn to be heard, you could present those to the court because you don't want to interrupt the other side. Have a plan in advance. Know how to get to the courthouse. If you've never been there before and it's not far from your house, you may want to just drive there a few days before. Write out a map or pull up a map on MapQuest and find out how to get to court if you've never been there. Give yourself plenty of time. You want to arrive early. Better to arrive early than late. You don't want that to work against you. And if you're appearing by phone, just know in advance what phone number you're supposed to call and when. Dress professionally. Remember, judges are human, so you want to make a good first impression with the judge. Wear a suit if you have one, but don't worry about it if you don't. If you don't have a suit, just make sure you dress nicely, dress professionally. For men, a collared shirt and nice pants and nice shoes. For women, professional attire. If you don't have that type of clothing, then simply church attire will do. A nice shirt, nice pants, nice shoes. Don't show up in holey jeans and a t-shirt. The first thing you want to do when you get to the courthouse is find your courtroom. Usually there will be a directory right when you walk into the courthouse, and you can find out which courtroom you're in, know in advance which courtroom you're supposed to go to. And then when you get to that particular courtroom, usually there will be a calendar or docket outside the courtroom, and it will tell you when your case is being called, what number, and then just go in and check in with the court clerk, let him or her know who you are, what case you're there on. What happens when your case is called? First off, you'll want to walk up to counsel table. If you've never been in a courtroom before, you'll recognize it's on the other side of what they call the bar, and there will be tables, usually 2 tables with a few chairs in front of each, and you will go to the appropriate table. Sometimes there will be an indication as to who goes to what table. Introduce yourself to the court when your case is called. Say good morning, good afternoon, Your Honor. State your name and the party that you are to the case. If the other party is not present, make sure you ask the judge for what's called a default judgment, which is requesting the judge to grant you what you're requesting because the other party's not there to contest it, that they didn't respond to it, and let the judge know that you properly served them and have that documentation to show that they were properly served and properly on notice, and therefore a default judgment should be issued if they don't show up. Follow the cues from the judge. This is provided the other party is there and your hearing is going forward. The judge will direct which party to go first. Typically, it's the party that filed the motion that brought the parties there before court. Oftentimes, the judge may ask if the parties have had a chance to discuss things, maybe even send the parties out into the hallway to see if there are any issues that can be resolved, and if not, then the hearing will be had. Usually what you will do is who's ever going first will start with their opening statement. Again, remember to have your outline with you, and then follow the judge's instruction as to when to present your case. Call witnesses if you have them when it's your turn to present your case. Any evidence you may have to present to the court, go ahead and present that. You'll again want to have 3 copies when you present those to the court. Be polite and respectful. This goes back to controlling what you can control. You want to be very polite and respectful, of course, to the judge, but also to the other party and their attorney if they have one. You want to conduct yourself in a very professional manner. Again, judges are human, and you don't want that to reflect poorly upon your case. Answer questions of the judge. Be responsive. The judge may interrupt you and ask you some questions. Answer the question. If it's a simple yes or no, answer yes or no. If you need to explain it, but be concise and short. And, I like to tell people, if the judge asks you what time it is, don't tell them how to build a clock. Tell them what time it is. Don't interrupt anyone. When it's your turn to be heard, and you'll know when it is, the judge will indicate, you will present your case. But when the other party's being heard or their attorney's talking, don't interrupt them, and especially don't interrupt the judge when he or she is talking. You speak when it's your turn. Again, when the other party or their attorney is talking and you feel you need to respond to something, just write it down on your notepad, and when it's your turn to respond, you can go ahead and you'll have that in front of you, be well organized in your response. And when it is your turn to talk, remember, speak directly to the judge, not to the other side. The judge is the one making the decision, not the other party, so you want to make sure you speak directly to the judge. As far as preparing your outline and what you want to say in court as well, remember the focus is on what is relevant toward your particular issues before the court. If it's child custody and visitation type cases, the focus is on what's in the best interest of the child. If it's a child support type case, the focus is on the relevant factors based upon state guidelines for child support, which are typically, reduction in income, a loss of employment, change in your parenting time, and other relevant factors. And again, you want to be as prepared as you can. That's the key. And then you have to have faith that the court will do what is best. But remember, you control what you can control, and you want to control all of those things to your advantage. Sometimes the judge will issue an order immediately after the hearing. Other times the judge may take the matter what's called under advisement and issue an order in the near future. If you're not sure what the judge is doing, just ask. Or any other things that have happened in court at the end of the hearing, if you're not sure, just ask the judge. You don't want to leave the hearing not knowing what happened. Best of luck to you.